those of you who don't know me, I'm Janet LeClair. I'm the executive director here at Memory Movement Charlotte. And Memory Movement Charlotte is now in its 9th year of serving patients and their caregivers and families, those diagnosed with a memory or movement disorder. Prior to joining Memory Movement Charlotte, I was Chief Operating Officer of the Ivy, which is an adult memory wellness day center here in Charlotte. And Joan Wright just was talking about how she volunteered there with her 2 wonderful dogs. And prior to that, I have really a long history of working in financial institutions and HR companies, in operations roles, managing large teams. And so I've seen a lot, both from an employee perspective, from a leadership perspective, and really have helped many individuals and their families deal with healthcare crises they faced over the years. And a healthcare crisis really presents incredible challenges to people, both on a personal and professional level. And we know they're facing a lot of unknowns. And so for that reason, I'm really, really excited that this program, that we're presenting this program to all of you. And we really welcome your thoughts and comments as we go through that. As I said, the healthcare crisis really presents people with the fear of the unknown. Should I tell anyone? Do I have to tell anybody? What do I say? Who should I tell? How do I tell? And what happens if I do tell or don't tell? And so with all those unknowns, I really wanted to talk about what many people are not talking about because they're scared to talk about. So we know that when people are dealing with something they're uncomfortable talking about or disclosing, it's very stressful for people, and it really is scary. And stress, as we know, is not good for your health. And so for that reason, I am really particularly honored to be here with our 2 guests today, both of whom have a lifetime of personal and professional experiences that they are more than happy to share with all of us today. And they are seasoned professionals. Both have long, successful careers in seemingly very different professional industries. At the same time, those lives are intersecting in an incredible way. One sister is navigating a life-altering diagnosis, and the other sister is there supporting her every step of the way. So without further ado, let me introduce our guests. First, Elizabeth Hodges. Elizabeth is a graduate of Chapel Hill and also a graduate of their law school. She has over 42 years of experience in family law. She is currently a principal attorney at Offit Kerman Law Firm here in Charlotte. She's board certified in family law by the North Carolina State Bar since 1989. And she currently serves as the president of the American Academy of Matrimonial Lawyers since 2008. She's won numerous Best Lawyer Awards and is published many times, a highly distinguished career. She was diagnosed with Parkinson's a couple of years ago, 9 years ago, and kept it a secret for many years. She is married 30 years to Ron Everhart, has a daughter and a son and a grandson, and of course, she has one sister, Ann. So Ann Hodges, her sister, has a BS in consumer behavior and a master's in education and business from the University of North Carolina, Greensboro. She has 30 years as a human resource professional, 24 of which as an HR leader at Pfizer. She's worked with all levels of employees with varying backgrounds and experiences. And she was responsible for a broad number of HR functions, including recruitment, talent management, compensation, benefits, conflict resolution, M&A, and training. So she's really seeing the full gamut from a corporate perspective. Beth or Ann, anything you'd like to add before we get into the conversation?
Just want to correct one thing. I'm no longer the president of the chapter, North Carolina chapter at AML. My tenure ran out. Other than that, it's accurate.
Okay, great. Great. Always need an attorney in the room to keep the facts straight. So very good. Thank you.
I have no caveats.
Okay. Okay, great. Okay. So Beth, tell us a little bit about your personal story and career track, including your time of diagnosis, where you were in your career, kind of just really from your perspective. Take us from then till now.
Okay. Well, I was diagnosed about 8 years ago. And what happened was I noticed one day that I had a tremor in my left hand. So I thought, well, I'm going to the doctor for other things. I'll ask about it. And his opinion was that I was drinking too much coffee. And I was so freaked out by, the fact that something was happening in my body that it didn't occur to me to ask him, well, if that's true, then how come the other hand's not affected? But I was diagnosed. Ann will tell you that I'm an extremely private person. I am very, very private. I keep things close to the chest. And so I was not going to tell anybody except my family. My family members have been completely supportive and have been awesome since that time. But I decided I was going to keep my diagnosis secret because for a couple of reasons. One is because I didn't know that much about Parkinson's when I was told that I had it. I thought that it affected only old people, and what the symptoms were that they shook a lot. So I was so ignorant of the facts there. So I went on Google to try and find out which was a mistake, because there are a lot of misinformation out there and a lot of half truths, a lot of good faith but misinformed people out there saying this is what Parkinson's was. So that further reinforced my trying to keep it quiet. So for a long, long time, I didn't admit anything to anybody except to my family. And I thought I was fooling everybody, but I was fooling just myself because other people noticed that I had symptoms. The difference in I was walking, how I was moving and everything. And people were asking my husband, what was wrong with her, anything wrong with her, and he kept silence. But it just got to be, to the point that people were just asking about that. So, I mean, that was a hard thing for me to struggle with because of my private nature.
Great. Well, thank you. Thank you. That was really a great summary. So Ann, as a sister and as an HR professional, as Beth was sort of navigating this whole 8-year span, what advice did you have for her during the course of that journey?
Well, I probably would break it into a few categories. As Beth can probably tell you, I was a big proponent of her when she was comfortable doing it to share with her employer and her coworkers. And I'm going to tell you why I say that. I really break it into a few categories. And I would tell anyone that they need to know their rights and their responsibilities, and they would need to be educated, and they need to foster an open relationship between the employee and the employer. And so if it's okay, just take a few minutes and talk about two of the main pieces of legislation. And I won't bore people, but I'll give them kind of the 40,000 foot view of it. And this is really where most of this comes from in terms of what's available for them. So basically there's two major pieces of legislation. One's the Americans with Disabilities Act, which everybody knows is ADA, and the other is Family and Medical Leave Act, which is known as FMLA. Basically, the ADA provides people protection against discrimination in the workplace. There's lots of other components of ADA, but I'm going to focus mostly on the workplace today. It's only, and this is important, it's only applicable if the employee tells their employer. And that's the key here. And that's why you'll hear me say a lot, it's important to have that open, honest relationship with your employer. And that's where the importance of the relationships come in. Basically, ADA covers employers that have 15 or more employees, which is most organizations. And it basically what it looks at is it, and I'm going to use the word disability because that's what the ADA, that's the word they use, but they define a disability from a legal standpoint as a physical or mental impairment that substantially limits one or more major life activities, or it's a record of such impairment, or there's a perception that the person has that impairment. So when you talk about major life activities, it's really most anything. It's vision, hearing, eating, sleeping, walking, speaking, breathing, reading. There's a whole list of them, but working's on that list. So the ability to hold down a job or the ability to work is considered to be a major life activity. So when they look at whether an impairment or a disability, as they call it, substantially limits a major life activity, they're going to look at a number of things. But in the case of Parkinson's, and I'm going to use this example because of what Beth has been dealing with, is Parkinson's in an advanced stage is considered to be a disability from a legal standpoint. So because Parkinson's is a progressive disease or progressive condition, a person may or may not be considered to have a disability under ADA. It's going to depend on where they are in the progression of it and what the specific aspects of their condition is. So as an example, stage 1 of Parkinson's may not consider to be a disability under ADA, but with progression, it might be considered a disability. So as it progresses, there's going to be a point where it could be considered a disability and therefore in need of accommodation, which I'm going to talk about here in just a second. The important thing is there's no one size fits all. So it's really important that individuals have these discussions, be as educated as possible as they can be about their condition, and foster that productive communication with their employer. Now, ADA also talks about what's the employer's responsibility and what's the employee's rights and responsibilities. And it talks a lot about prohibiting discrimination against someone because they have a disability. So in other words, if someone has Parkinson's, for example, they cannot be discriminated against if they can perform the basic functions of the job, or excuse me, the essential functions of the job. And I think one of the things that people struggle with is how much do we tell our employer about our condition? And no one would expect an employee to reveal everything about what they're dealing with or what their medical condition is. And in fact, as an HR person, I would advise them not to, and I would advise an employer not to ask the questions because, for example, an employer can't ask a candidate that's interviewing for a job whether they have a disability or conduct a medical examination to find out what's going on. They can only ask the candidate if they can perform the essential function of the jobs. Where it comes into play that the employer needs to know that there is something going on when it comes to accommodations. For example, if we use Parkinson's as our example, as it progresses and the person is exhibiting symptoms and it begins to impact their job performance, an employer cannot the employer can't guess what's going on. And when they don't know, they're going to fill in the blanks with information. And there's a lot of misperception out there. So they're going to fill it in probably with the wrong information. So the employee would be expected to make a reasonable accommodation for a person if they know the person has a condition that needs a reasonable accommodation, as long as it doesn't create an undue hardship for that employer. Now, what do I mean by that? When you're talking about undue hardship, basically the courts, the law will look at how much did this accommodation cost? What are the overall financial resources of the company? And it's going to be evaluated on a case-by-case basis. What you need to keep in mind is that the accommodation just has to be reasonable. It doesn't mean that it's the accommodation that the employer wants it to be. And I'm going to talk later about what are some examples of accommodation. But keep in mind, it doesn't have to be difficult and it doesn't have to be expensive, but the employer does have to understand what it is that you need. And if they don't, as I said before, if they don't know or they don't understand, they're going to assume something. And 99% of the time, it's not going to be an accurate assumption. And therefore, they're going to have no choice but to address it from a performance standpoint. Now, I'm going to just very quickly, because I know we're going to get more into detail about this later, but I do want to mention FMLA, which is the Family and Medical Leave Act. Basically, the FMLA requires that larger employers allow employees to take time off to fulfill certain caregiving responsibilities, such as a new child, whether it's the birth of a child or adopting a child, taking care of a family member, or to take care of their own health issues. And if your employer is covered, an eligible employee can take up to 12 weeks of unpaid leave every 12 months. The reason I say it that way is that the FMLA doesn't require that the employer pays you, but many employers have it set up that you can take vacation or some type of other leave that is paid. So it would be important to check with your employer what that is set up to cover. And the only condition on employees is that they've worked for at least 12 months and at least 1,250 hours during the previous year.
Mm-hmm. Great. That's some really great overview of some of the protections that are available to employees in large organizations. So thank you for outlining that. So turning it back to Beth, can you share with all of us how long you hid that diagnosis and what did it feel like to know you had Parkinson's, but were trying to kind of keep it to yourself?
And I was diagnosed about 8 years ago, and I kept it to myself until, and what it would be last year?
Yes. Mm-hmm.
Last year. And that's when I started to realize that my subterfuge was not working. So I decided, and it took sort of an epiphany that I realized that people, like Ann referred to, people, if they don't know what's going on with you, they're going to assume something that's usually not right. And usually it's worse than what it was. People were assuming, I thought, people were assuming that I was ill in a way that was worse than Parkinson's. And so, and also there's some misinformation being circulated. So I decided I was going to take control of my story by being the one to go out there and say, this is what's going on with me, and this is what it means. And if you have any questions, ask me, and I'll be happy to help you with it. Don't assume anything. One of them is don't assume I can't do what I want to do.
Mm-hmm.
You know? And so once I made that decision and decided that I was going to, so to speak, come out, it felt better because I had all this stress and all this tension on my shoulders, trying to hide things from my friends and family, not family, but from my friends and colleagues, that once I decided I was going to be open with it, then it was almost immediately this release of tension just came through. And it felt good,
Mm-hmm. So, you shared earlier in your intro that you're a very private person.
Mm-hmm.
How much of you're keeping the diagnosis to yourself had to do with that versus just fear of what other people would think? Or they...
Well, the drive to be private is always there, but I did want to keep it silent because I was afraid of what people may think. You know, it wasn't so much I was afraid that I would lose my job. I didn't think so because I was a principal and I was a partner, you know, so I knew that that wasn't going to happen. But there, you know, rumors can spread through the community, and I didn't know how it was going to affect my not my own personal ability to do my job, but my ability to communicate effectively with others who may think something is wrong. You know, and so, and part of doing family law, you have to go in court, and so there were a lot of court appearances, and so and that was stressful too. So they were all kind of mixed together.
So how did you, after disclosed, you shared that you felt better. Did you feel like you felt better emotionally, as well as you feel like it had any impact on your symptoms? Do you think your symptoms were exacerbated by keeping this, you know, secret inside?
Yes, it definitely was, because the stress triggers my symptoms more than anything else. You know, if I all of a sudden am approached with a problem I have to do that's like, I don't know, that would just trigger the stress, I immediately start reacting.
Okay.
So I thought that, and I do feel that, you know, with coming out with this information and saying I'm going to be in control of my life story, that releases that stress that I've been experiencing for years.
Great. You know, that's a lesson that can apply to so many situations in our life, and one that some of us never learned, and others way too late in life. So thank you for being you know, a trailblazer for many of us there. So thank you. Good. Okay. So so can you talk a little bit about, I guess, Ann, I know you talked a little bit about the employee has rights, but they don't have any rights if they don't share the diagnosis. You went through the laws and the protection.
Right.
I think, you know, Beth would acknowledge her situation is somewhat unique in that she's a principal of a law firm. She's working with professionals she's worked with for a long time. So probably had less fear of losing a job.
Yes.
And so that is not always the case for many people. And we also mentioned that oftentimes, whether it's a Parkinson's, where the symptoms are more physical in nature versus a cognitive impairment, you know, oftentimes performance issues are really what surfaces as the conversation.
Yes.
So can you talk a little bit about, you know, what employees should do in that situation, and how to kind of read the tea leaves, if you will, on when and what they should say?
Yes. And I want to tag on to something Beth said. It is a little different than her situation. And I'm going to use my experience with Pfizer, which is, you know, a Fortune 100 huge corporation. People are afraid of sharing this kind of information from the sense that they think they could lose their job. And what I usually try to help them understand, and it's, let me preface by saying it's a process. It's not a one conversation. It's a 1, 2, 3, 4. It's got to be ongoing conversations with your employer. And the problem is, and the short answer is, the employer cannot respond accurately to something they don't know or they don't understand. And if your performance starts to suffer and they don't know what's going on. And I'm going to talk a minute about, we're not telling you to share your medical condition at all. And I'm telling people not to do that, to the specifics. But if they don't know what's going on, they're going to assume it's performance related. And I saw this happen over and over again. What happens is the manager starts addressing the performance. Hopefully it's progressive discipline, but it's over time. And the performance gets worse and worse. And particularly with something like Parkinson's, because stress aggravates it, they're becoming more stressed, as anyone would, as the performance starts to suffer, and they start, their employer starts, dogging them, saying, hey, why aren't you doing your job?
Right.
And then ultimately they're terminated. And, if they're waiting until they're terminated, so, but, wait a minute, I had this condition. The employer is not retroactively expected to have done something because they did not know.
Right.
So what I tell employees is that you need to be able to have that, you need to work on having that relationship with your employer, and what you're sharing with them, it's not the specifics of your medical condition. It's that I have this situation and I need to have accommodation for it. And those dialogues have to be continuous. And I'll use Parkinson's as an example. Parkinson's has cognitive and physical aspects related to it. And it's going to change over time. So the type of accommodation that you need most likely will change. And so you've got to be able to have those ongoing dialogues. It's always better to have that conversation, and with accommodation, more often than not, what's happened is that the person's performance goes back to where they want it to be with a simple accommodation. Now, at some point, it may be a case, and I know I'm kind of jumping ahead, but at some point, it may be a case where it can no longer be accommodated because it's become so significant. And then because you already have this ongoing conversation and relationship with your employer, you should know about other options for you at that point. It's going to depend on the employer, but whether it's short-term disability, long-term disability, whatever it might be. That's why I said it's a process and it's an ongoing conversation.
Okay, great. Well, just to be, maybe go down a level of detail, just when you say not to disclose medical information, but what do you disclose? So in a situation where you have physical symptoms, but they're not in any way affecting your performance or your ability to do your job, but they may be visible and noticeable to others. What would you suggest somebody say to their manager?
Well, and that is often how it happens. The way it normally happens is that the person thinks, the employee thinks that, oh, I'm doing fine. The employer sits down with them, says, hey, I've noticed X, Y, Z. And the employee goes, oh, wow, I thought I was doing okay. At that point, I think is a good manager will say, hey, what's going on? I've seen your performance suffer. And that's the opportunity for the employee to say, yeah, I've got some medical challenges going on. And can we talk about what assistance I might be able to get, or what accommodation I might be able to get to help me in this area? Where I draw the line and where I tell employees not to talk a lot about, or employers to ask, is specific details or specific nature and severity of the condition. So what you're really addressing with them is, so let's say it's Parkinson's, and the individual is having difficulty from a cognitive standpoint, focusing on things later in the day. The discussion should be more around what can we accommodate related to that. So maybe the schedule changes and the person's doing more difficult tasks earlier in the day.
Mhm.
It doesn't need to go into a lot of detail, but the employer has to know enough that they know what they're accommodating. Does that make sense?
Yes, yes, yeah. So one thing I would say that in everything you shared, which is excellent advice, there's an assumption of an element of trust. And
Yes.
okay, so some employers may say, well, hey, I don't believe that. Get a doctor's note. Is that something that would be,
That's okay. That's
that's okay?
okay. Yeah, that's okay. There are often times where, I'll tell you in my time with Pfizer, and this sounds like a crazy example, but it's the one that comes to mind. I have, and I don't even mean to equate it with anything anybody else is dealing with, but Beth can tell you, I have a phobia of flying.
Mhm.
And my job required me to be all over the country. Well,
Wow.
I got a doctor's note that said she has she has a fear of flying. If there's another way for her to travel, you guys need to pay for it. I mean, I'm giving you
Yeah, no, exactly. Okay.
the
Mhm.
the blunt version. And if she has to fly because she has claustrophobia when she flies, she needs to be in first class.
Okay.
So I know that's kind of a silly example, but it's one to say that a doctor's note, it is appropriate. And
Mhm.
now most doctors are not going to go into any details. What they're going to say is this individual needs to have accommodations in the area
Mhm.
of. It's basically
Okay.
what they're going to say.
Mhm. Okay. Great. Great. Okay. So in the event that performance does decline, um, can you speak a little bit about how that does affect job security and what benefits like health insurance and
Yes.
kind of-
Yes. And everybody needs to speak with their specific HR person or company, or learn about their own, what benefit setup they have.
Mhm.
But often with an employer, what happens is, again, as I mentioned, it was a process.
Mhm.
It make it to the point where the person can no longer be accommodated. So for example, a reasonable accommodation is not for an employer to totally give you a new job. The courts have not upheld that. They have not said that that is reasonable. If an employer has a job, they need that job done. So
Mhm.
if it's a case where they cannot accommodate you in any way, then there should be some dialogue around, okay, I can't work anymore. Therefore, short-term disability, long-term disability, Social Security disability. So for example, a lot of companies, the way they're set up is you go on short-term disability for a period of time, and then it goes into long-term disability if you're not able to come back to work
Mhm.
during after your short-term disability. Some companies allow you to buy up. And what I mean by that, long-term disability, instead of it being, for example, 50% of your
Mhm.
salary, it can be 70% of your salary.
Right.
You
Mhm.
need to look into that. Some companies do also provide long-term care insurance.
Mhm.
So these are all things that I would strongly encourage folks to learn about. And you can also purchase long-term care insurance on your own. There are
Right.
a lot of things that people need to be planning for. Parkinson's, because it's progressive, there is a time factor attached to it, meaning you've got some time to start planning for
Mhm.
things down the road. So learn what your company has to offer, and then make some plans.
Okay. Okay. What about caregivers? Many of our participants on the call
Yeah.
are caregivers. Any protection or
Not
support?
not under ADA, but there is under FMLA. And basically, and I'm just pulling this up real quickly, so bear with me. Under FMLA, there is the protection for people that are taking care of someone, and it's called an association provision
Mhm.
under FMLA.
Okay.
and under ADA. Now, let's talk about ADA for a second. ADA doesn't provide them any reasonable accommodation rights because it's not their own condition.
Mhm.
But there is what they call an association provision, which they are protected from discrimination because they are associating with someone with a condition. And that sounds like, why would you need that? Why would an employer think negatively about you and take action because you are associating with someone with a condition? Believe it or not, there may be the perception that, okay, you're going to miss work because you're taking care of someone. Our health insurance premiums will rise, because, and so it really comes down to the ADA protecting you because there's a perception that the employer's going to suffer because you're spending this time with someone else or taking care of someone else. Now, under FMLA, there is job protection leave for a situation, where you have to take care of someone, which that was there before. That was there before with FMLA.
Okay, great. All right, so let's turn it back to Beth. So, as you're listening to all of this and reflecting on your story, what do you wish you knew 9 years ago or 8 years ago that you wish you knew now? And what advice would you give to someone who is facing a new diagnosis?
I wish I knew back then that all the hiding and stuff wasn't going to work, because my symptoms are physical, and there's only so much that I can do with the physicality of the disease. And so I would have saved myself all that time of being stressed out and exacerbating my condition. I wish I'd known that back then. And also I wish that I'd known that, there are different forms, there are different ways that Parkinson's manifests itself. No two people have the same impact on disease. They're all different. And so knowing that, and knowing that the truth will set you free, so to speak, that I would have been more open back then.
Great.
I think it would help me.
Great.
And apparently, from what Ann's saying, it helps in an employment situation too.
Yeah, absolutely. And you're really helping so many people who are grappling with that dilemma. And again, it's such a liberating feeling, I'm sure, just to know that I don't have to hide anymore. And
it really is.
Great. Good. All right, well, wanted to turn it over to Melanie. I don't know if we have any questions from the audience for our guests here today.
If anyone has any questions, now is the time. I've muted everyone, I think. So you will need to unmute yourself by tapping that microphone again. If you have a question and you'd like to say it out loud, we'd love to hear your voice. And if you prefer, you can put it in the chat box and we can read it. But we are here for questions.
I have a question.
Go ahead.
I have a question for Ann. Can y'all hear me?
Hi.
Hi. So I have schizophrenia, and I was thinking a lot about you saying not to disclose too much. And of course, schizophrenia, there's a ton of stigma associated with that. I've had psychiatrists in the past that didn't know exactly what to tell my employer, and it sounds like they gave them way too much information. Symptoms and diagnosis and everything, along with some accommodations. But can you elaborate on reasons why it's not in your favor to give them too much, and are you not protected even if you give them too much information? Is there things that you wouldn't be protected from?
Okay. Yes. And let me preface this by saying I'm speaking purely from an HR standpoint. And I'm gonna, I will start by saying it is not in the best interest of the employer to have all that information. And let me tell you why. The assumption is that if an employer has information, they're using the information, even if they're not. And what I mean by that is, let's say you had a legitimate performance issue unrelated to your schizophrenia, and the employer wanted to address it, and they ended up terminating your employment. The assumption is they used that information to make their decision, even if they didn't. So I'm always telling an employer, be careful what you ask for. And the employer should always be focusing on, can you perform the essential functions of the job with or without accommodations? So I'm back to the first part of your question, which is what should the doctor, or does a doctor reveal too much? The employer needs enough to know what they need to accommodate. So a doctor would have to be able to provide to the employer, my patient, John Smith, I'm sorry, I'm not using your name, but my patient, this individual would need to have accommodations in the area of. Because there is so much stigma attached to schizophrenia, my concern would be that if there is going to be there's going to be information that they're revealing about your condition, that they're not giving too much. They need to be able to say, this person needs to be able to have flexible work schedule, whatever it might be. And I'm going to interject something. I'm doing a little bit of segue, and I apologize. But one thing we learned through COVID the last 2 years is that despite what employers thought before, things like working from home actually have resulted in more productivity, not less. And we've got plenty of research on that. We also have a shortage in labor right now. We don't have enough people to fill jobs. So I think moving forward, there's going to have to be a lot more appetite from an employer standpoint around things like flexible work schedules, working from home, all things which are considered to be reasonable accommodations. Now, is this answering your question at all?
Yes, it does. Is it okay if I ask a second question?
Sure.
So
Absolutely.
what I've done in the past is I've waited until that initial 90 days was over. I guess out of a feeling of that's more protection on my part.
You mean the probationary period of a new job?
Yes.
Okay.
To disclose.
No, you're protected from the point you apply for a job, interview for a job, because whether you're looking at ADA or a state or local provision, it protects anyone in the job process, whether it's applying for a job, interviewing for a job. Now, I would never, ever, you shouldn't, in an interview, the employer should only be asking, can you perform the essential functions of the job? They should not be asking you anything about your medical condition. During the interview, you're mainly, and so let's talk about the, a schedule. So an employer might say, can you meet an 8 to 5 work schedule? And your answer is yes or no. That's an essential function of job from their perspective at that time. And you're answering yes or no. There should be no discussion around your medical condition at all. Now, some employers will ask you, do you have a need for an accommodation? But other than that, there should be any reference to it. and that you are protected in the 90-day probationary period. The 90-day probationary period is merely to assess whether or not you can, you can do the job functions if you're a good fit for the job. But there's still protection for you because you're still an employee of the company.
This is Sanjay Iyer, and I have a question. First, thank you both for your comments. They're very articulate. I have to often field questions from some of my patients who will ask when it's time to disclose, or if they feel like they need to come forward in some way, should they speak to their supervisor initially? And then my follow-up question is, oftentimes my patients are concerned that their employer will have some level of ongoing access to their medical records. So if you could speak to those 2 points, I'd appreciate it.
Do you see me shaking my head? The employer would not have access and should not have access to their medical records. There's no need for it, because keep in mind, the employer only needs to know whether or not the person can do the job with a reasonable accommodation and what that reasonable accommodation might be. And we haven't talked about what types of accommodations are, but they can be inexpensive and they can at times cost no money at all. And with technology the way it is today, there are a number of things out there that an employer, even a smaller employer, can get with, for little to no expense. And a company like Pfizer, which is a Fortune 100 company, would be hard pressed to say much is unreasonable or create an undue hardship from a financial standpoint. So no to the sharing the medical record. Now to the first part of your question, at what point should the employee be having these dialogues? It's going to usually come about in two ways. One that I mentioned before, that the employers actually noticed a change in their performance and they initiate the conversation. That would be an opportune time to start having the conversations. Or if the employee themselves has noticed some changes in how they're performing the job, they can initiate the conversation. My view has been it often is better coming from the employee than the employer, if that makes sense.
Is it better for the employee to approach their immediate supervisor and let them know that they're having a medical concern, or should they first approach HR? Sometimes the comments that I hear are that they're not sure whether HR is working for me or for them.
Yeah. You know what? And I'll tell you, let me say that I was never the typical HR person. And I always told people, you don't want it to become an HR issue, because that puts a whole nother level on it. No matter how nice the HR person is, you want to, if at all possible, have that good relationship with your manager and have that conversation. Because here's what happens. The person goes to HR and says, this is what's going on, whether we're talking about a need for an accommodation or we're talking about some conflict in the workplace. They go to HR calls the manager, and the manager's like, well, why didn't they come to me? I thought we had a good relationship. It puts it at a whole nother level. So if you can avoid that, and HR, you can hear HR people around the world screaming at me right now, but I think it puts it at a level it does not need to be. My view is that while I represented the company, what's good for the employee and good for the employer is absolutely not mutually exclusive.
It's a great attitude.
Did that answer the question?
Thank you. That's a great answer, and it really does. It really did, and because they often ask me who should I talk to, and I never know how to advise them. So thank you very much. That was great.
You're welcome.
Any other questions? Okay. Well, we have a few thank yous. First, we would like to thank our guests. Thank you so much, Elizabeth and Ann, for sharing your experience and your expertise and all the free advice. I have a feeling this is an episode that will be watched and recording for a long time. And we really, really appreciate your time and your wisdom.
Allowing us. Thank you for allowing us to come and
Thank you.
talk about the subject.
Thank you.
Our pleasure. Come back anytime.
Right.
Okay, we also would like to thank Embrace Care and Southminster. This program is possible because of the generous sponsorship of Embrace Care, which is Southminster's home health service. And if you were not aware, that home care service is available outside of Southminster now. So you do not need to be a resident of Southminster to use the services of Embrace Care. Southminster has been a supporter of memory and movement for years, and we share a philosophy about aging with dignity and health and independence. And for that reason, we are very proud to announce, if you've missed this announcement, we are beginning on April 6th to have a satellite clinic at Southminster at the Embrace Care Clinic. So memory and movement doctors, including Dr. Iyer, will have rotating schedules of hours at Southminster. So if you are a resident of Southminster or you know someone who is, they can now see their doctor by riding an elevator. So that's a lovely service. And we hope to be able to expand that opportunity to other locations and to patients who are not residents of Southminster once we sort of get rolling and see what the capacity is. Thank you so much.